Hi friends, how are you? Today is the Rakhi day. All of you feel God blessed. May your sisters and to all the sisters, may your brothers, you be lifetime together. And I pray to God to bless all the sisters and brothers to infinity. Be happy. I have been trying to comment on Gujarat High Court judgment that allowed input tax credit for input services by way of section 54, that is cash refund. Now, friends, this refund was even earlier allowed, but it could not be claimed under Section 54 as cash refund. So now, when the matters went to Gujarat High Court, so a ruling has come which says the Rule 89, Sub Rule 5, and the formula that it appended with itself to disallow the input tax credit in the calculation of cash refund, eligible cash refund, has been read down and say this is contrary to the legal provisions of CGST Act 2017. Now, friends, what is inverted duty structure? Now, GST law has a scheme that says that the USP of GST law, when the model law was shown to the world by India, that it shall allow a seamless input tax credit. That is, at the level of manufacturers or exporters, no tax on purchases shall be built in, and there'll be a full credit allowed, and only output supply, that is the consumer who is to consume the goods or services or both, shall pay the full tax. This is the world over, we know GST. As we know, in India, we did not actually implement the GST. We refined it to a all India level VAT with 6, 7 rates and the 3 layers of GST and the Cess Act, all these combined factors. I think they demeaned the concept of GST. Notwithstanding the views on the GST law, we really celebrated when India reformed this indirect tax law, which subsumed all major indirect tax law except custom duty. And we were all happy as professionals, as industry, other stakeholders, even consumer. Consumer was also happy as if they will know what is the tax burden they're bearing. But as the law came along, the rules came along, hundreds and hundreds of notifications, circulars, clarifications, advanced rulings, High Court judgment, Supreme Court judgment, arrest, raid, attachments, evasions, unjust enrichment, all these issues that had plagued the earlier indirect system also plagued the newly introduced GST law. Now, GST law is basically a concept of a 2-pin theory. On one pin, you hang all your purchase vouchers, tax invoices, and on the other pin, you hang over all the output tax invoices, that is output supply. So whatever inputs is, you set off against the output tax liability. That is the purpose of input tax mechanism. So the law defined in section 2 what is inputs, what is input service, what is input tax, what is input tax credit. The definitions did not distinguish between the input tax credit on goods or services. Input tax credit included all these together. The other new point which I want to discuss is section 16. Section 16(1), which is the primary section and read with section 2, which gives input tax credit. It does not use the word input tax credit. It uses the word tax on supply of goods or services or both. So section 16, while giving input tax credit, subject to section 17, 18, 19, 20, 21, 22, 21, did not place any kind of restriction. So you could claim input tax credit for everything. There is no bar. But the bar came when you go to take cash refund. Section 54 clearly said a cash refund is possible under 2 situations. You make zero-rated supplies under section 16 of IGST Act, or you indulge into a kind of tax system where there is an inverted duty structure. Inverted duty structure happens when the inputs of goods or services or both you use to manufacture or trade or supply the goods on which output tax is lower than the input tax credit. These situations result into inverted duty structure issues. And this says you will be allowed refund of inverted on the basis of inverted duty structure also. Along with this came many notifications where the government, for its own purposes, not for the purposes of the taxpayers, reduced the tax rates but denied the cash refund or the input tax credit. For example, supplies to railways, certain HSN-based goods, 5%, no input tax credit. So all these things, there are many more things on this issue. Now, when government realized that there is a huge amount of industry which uses services of various kinds, and they will also claim refund under 54.3, they came out with a circular in December 18, effective retrospectively, 1st July 2017, where they, to Rule 89, Sub-Rule 5, they appointed a formula. The net effect of the formula was, when you were computing net input tax credit for the purpose of cash refund for Section 54, it tended to exclude the input services. Now, once you exclude the input services, only for the purpose of one particular class of dealers who are engaged in inverted duty structure, obviously as a lawyer or as a professional, we will invoke Article 14. How can you do this kind of discrimination between the taxpayers who are not involved in inverted duty structure and between taxpayers who are involved in these kind of transactions? So all these questions came up. I mean, the footwear, the job work industry, the works contract industry. There are a number of industries where these kind of services are huge. And normally taxability 18%, except job work, which could be termed as 5%. Now, all this led to a lot of problems. There were a lot of hue and cry. And before the Gujarat High Court judgment also, as professionals were discussed at various webinars, and we were of the view, this kind of artificial rule or the formula being fit in to deny people their legitimate right to input tax credit on services used for making taxable supplies or exports, etc. But in came the Gujarat High Court ruling in VKC Footsteps and others. Now, before High Court, one issue is this formula is invalid. It's contrary to law. But I want to highlight other thing what happened in Gujarat High Court. The senior counsels went into the international VAT system. Senior counsels also went into the GST draft clause. The senior counsel also went into the objects with which the GST was introduced in the country. They cited many examples. And they said, if you are trying to defeat the basic fabric of GST law by denying people input tax credit, which is not warranted by this, the main act, you cannot do it. It is not possible. And they also went, the GST was supposed to be a seamless input tax credit mechanism, which so far it has failed. Especially when they quoted a judgment of Indian Express, where the papers used for newspapers was subjected to a different treatment, and the Supreme Court observations thereon. Then the Gujarat High Court also realized that there is something in it. So Gujarat High Court noted all the contentions of the senior counsels and of the government. Government, of course, as usual, repeated that we have Section 164, we can frame the rules. We have all the powers using notification and circulars. But Gujarat High Court, in their concluding paragraphs, they noted the GST scheme, they noted the international VAT mechanism, GST mechanism, and they also noted the judgments of Supreme Court quoted before it. Then they said the purpose of Section 164, where government has power to make rules, etc., is only for the purposes of the Act. But something which is not authorized in the Act, How can you issue a notification or or frame a rule or issue a circular, and through circulars you deny people their legitimate right to claim input tax credit on services? So Gujarat High Court said the language and phraseology used for the purpose of input tax credit mechanism through section 2 in definition clause and through section 54(3), especially subclass 2, they are unable to reconcile any of these provisions, including definitions. They end up denying the taxpayer the cash refund on input tax credit if it's involved in transactions relating to inverted duty structure. So once they examined the rule 89 sub rule 5 and the formula appended to, the Gujarat High Court clearly said, okay, look, this is not a part of the scheme of the act. And they quoted many judgments, including Delhi High Court judgment, which was quoted extensively, international consultants relating to service tax, where they said the rules are subservient to the act. They can supplement the act, they can't supplant the act. So you framed the rule 89.5 and issued a circular for what purpose? Especially with the explanation too, is you don't want to give the credit on input tax services. Therefore, Gujarat High Court came to conclusion, the answer is that your rule is contrary to the scheme of law, scheme of the act, that is section 54, read with definitions of these 4-5 words in section 2. Therefore, the input tax credit has to be given. The court stopped here. In my view, the court should have known, once they were discussing section 54, court should have been aware, or court should have been made to aware there are limitations attached in 54.1. What is the limitation? A registered taxpayer can make an application for cash refund before the expiry of 2 years. It is not within 2 years. It is before the expiry of 2 years. You have to make an application. So what does it mean? It means if you do not make application, if a registered taxpayer does not make an application before the expiry of 2 years, he cannot make the refund application after the end of this period given in the act. That is, his refund claim shall be time barred. Now, this issue should have been discussed. This issue has been left blank. Maybe it was not argued, but High Court, since they were hearing a writ petition, they could have taken this suo motu and said, okay, now you give the refund back. Now, friends, all this we all know from various WhatsApp groups, what happened with Gujarat High Court judgment. I'm going a step further on this. What about capital goods? What about the various schemes the government has introduced, like restaurants, 5%? How can they mandate these kind of schemes? Under what law? Though restaurant scheme is not a composition scheme. Similarly, real estate builders. All these schemes need to be challenged by us. Okay, these deny us our rights to claim input tax credit by creating an artificial class of taxpayers. In restaurants, there is a huge capital investment, huge number of services used. So therefore, wherever government thought, okay, the capital goods and services are more than the perhaps output tax that they could collect, they have either framed this scheme, all those sellers have come at a flat lower rate without input tax credit, or through this rule 89 sub rule 5, they have denied the input tax credit. Now, this is simply not on. In 3 years, how much litigation we already have? First, we had section 143 transitional credit. As you know, I have been an advocate on section 140 and written many articles, addressed many webinars, and gave videos on judgment of brand equity, gave video on Supreme Court when they state brand equity. But as you go along, you learn more and more. What have they denied? The Jairam case or other cases, they said ITC is a concession. It is not your vested right. But for the transitional credit, I'm not claiming a vested right. The tax was already availed during those tax regimes. Only transitioning of that availed input tax credit under excise service tax or VAT laws has been delayed by me on various issues. So it is not that I was claiming that right under GST law. In GST law, you can say ITC is or is not a vested right. But on transitional credit, that credit I already availed. That was my money. That's what Delhi High Court said under Article 300A. ITC is a property which cannot be taken away. But again, there are judgments to or for contrary. Delhi High Court supporting, Nabharan High Court supporting, Delhi High Court, especially the brand equity. Recently, even last week on 20th July, there is a Madras High Court judgment again on PR Money Electronics, where they repeated NALCO case vehemently. Okay, look, the rule 117 is mandatory because to claiming input tax credit is not a vested right, it's a concession given by the lawmakers. Notwithstanding this issue, notwithstanding the fact that the brand equity judgment has been stayed by Supreme Court, who stops from the states to give credit? Why can't they stop litigation? I don't think Supreme Court will say, no, you will not give credit till we say. They have only stayed in operation of a particular judgment. There are enough Supreme Court judgment which says, notwithstanding a judgment, a beneficial judgment is stayed by Supreme Court, that the states cannot give benefit, but states don't want to give it. Similarly, they brought in Rule 36 for notification. You will get 10% of the eligible ITC if there is a mismatch in 3B and 2A. Again, they created controversy. And what about capital goods? Intentionally, the lawmakers excluded capital goods from the definition of inputs. And capital goods are huge, whether it's a transaction of works contract, transaction of infrastructure, transaction of manufacturing, restaurants, builders. So what happened there? So that means you never intended to bring in a seamless input tax credit mechanism. It's not happening in other countries. So courts have to intervene. In came the Safari Retreat judgment, which is not being implemented by the government for reasons best known to them. Its operation is not stayed by Supreme Court. So SLB is admitted. In Safari, they said, no, you cannot read 17.5 small d to mean even when a mall is constructed for completely letting out, as you will say, it is built out for your own use. And they allowed input tax credit. And when SLP filed in Supreme Court did not stay it. Why not? Because Supreme Court will be concerned if you have these kind of issues, then what happens? Similarly, this case of bogus dealers, fake invoicing. There is no doubt the purpose of section 16, 17, 18, 19, 20, 21 is to grant input tax credit for actual transactions, not for fake transactions, not for circular trading, not for paper transactions that happen only on paper. But when they frame the law in a way, the taxpayers get a legitimate expectations that their rights will be honored by the government. Now, we have thousands of cases where they say the supplier was a bogus dealer, or he was buying goods from a bogus dealer. Therefore, he supplied to you as a third recipient. Therefore, your transaction also got tainted with bogus transactions. Well, friends, this is not on. Similarly, you have started arresting people under section 132, and you are raising all kind of issues there. Bails are not given. In section 83, you start attaching properties with or without following law. So what are we doing in GST? What we are doing in GST is that we have created laws in a hurry that were totally unclear. They were not in sync with the rules. Now when you amend the rules go out of the main act. They do not supplement, but you end up framing rules or notifications or circulars. They supplant the provisions of the act. And there have been series of judgments. So therefore, Gujarat High Court judgment is the first judgment where a particular provision of the rules framed by the government have been read down and say they are contrary to the legal provisions. There are many other rules that can be challenged today. Now, what is the fallout? Fallout is definitely SLP will go. My view is Supreme Court will not stay this operation of the judgment for the simple reason. But once a particular rule that defies the language and the definitions used in section 2, once a particular word is defined in the act, then wherever the word is used in the act, it has the same meaning. So the definition clause has not defined whether input as credit or input service to exclude input as credit on services. So wherever the word input as credit is used, any input as credit, it means everything. Only because you had the rule-making power under section 164. But that power is available only for the purposes of the act, not for defining the purposes of the act. So Gujarat High Court judgment is welcome, but we lawyers still have to do something more. Now, if we go on a theory in GST regime, not the transitional input as credit, if we go on a theory, which many of us advocate, input as credit is a vested right. It is my property under Article 300 capital A of Constitution of India. You cannot take away. If it is so, if it be so, then the time limit in 54(1)(a), that is before the expiry of 2 years, has to be held to be directory. I must be given my claim because I have not been able to claim because there was no judgment like Gujarat High Court earlier. So we lawyers have to explore the possibility and challenge this. We have to put up challenging the High Court by way of Article 2 to 6, or write to the government or write to GST Council. A judgment has come now. You cannot defeat my right to claim input as credit because I was entitled to it. It's my money. It's my property, which you took away by framing an artificial and arbitrary rule. Number 2, capital goods, especially capital goods for exporters, for restaurants, for mall owners. This is a huge area, very, very huge area. Therefore, we also must start challenging these things. How can you deny capital goods? So if you deny capital goods, you deny me input as credit, input services, what is left? Only goods. Change the act. Most likely, there is going to be a retrospective amendment under section 54, subsection 3, subclause 2, to deny input as credit on services. I'm very sure. The government will know if they go to Supreme Court, then it can open the Pandora box for capital goods as well. Similarly, the government continues to struggle on export of services on intermediaries. Again, before Gujarat High Court, there was a challenge whether section 13, subsection 8, subclause 2, which says the intermediary POCs in India, whether this is constitutional. Gujarat High Court examined it and said this is constitutionally valid. But these intermediary services all over the world are in the course of export. And Central Sales Tax allowed this definition in the course of export. So if you are trying to create artificial stumbling blocks in the ease of doing business, then friends, our government must think that GST is not prospering. It is fading day by day. It is failing. It will fail again. The revenue is not going to come. Government has to reduce litigation. The government must not become a litigant in every issue. They should accept, or they should rewrite the law and make people clear what they want to give, what they don't want to give. Let there be a clarity of law. Well, friends, thank you so much for watching this video. 73, 74, 75 in next 3-4 days is under preparation. But on this particular judgment and the other issues I wanted to comment. Thank you so much for watching. Thank you so much.